want to introduce to you the 37th Attorney General of the state of Florida, elected in 2010, Pam Bondi. She's a UF graduate of Stetson Law School, 18 years a prosecutor, fourth generation Floridian, born and raised in Tampa. One of the great things I can tell you about General Bondi is that I know in the last 6-8 years many of us have become disillusioned with many elected officials who run, shall we say, for office a certain way and purport certain principles and then govern differently. It's not true of General Bondi. She understands the principles that have made this nation great. She understands the importance of limited government, protection of private property, the rule of law, and of course is the lead on these conglomeration of states who are fighting the implementation of Obamacare. She's a warrior for liberty. She is a fine, fine person. Please join me in welcoming Attorney General Pam Bondi.
Thank you all so much for having me here today. And I want to introduce to you some of my staff. Jason Rodriguez, who many of you I think have met, and Carlos Muniz, my chief deputy, who talk about a true conservative. I couldn't do this job without you, Carlos. He went to UVA undergrad because he couldn't get into Florida. And Yale Law School, editor of Yale Law Review, was Governor Bush's general counsel, and I am so blessed to have him working hand in hand on this healthcare fight. And first I just want to say, I met Bob early. I had never run for anything in my life. As the sheriff knows, I was a almost 20-year prosecutor. And I will continue to say I'm not running for anything else. This is it. 8 years of this, if you'll put up with me. And then my fiance will divorce me before we're married if I run for anything else, I think. So I'm headed back home. But I met early on with Bob, and we were talking about that this morning, in a little coffee shop. And I'll tell you what, you're so blessed to have him with JMI, because he is truly, I called my fiance, who's a physician, and I said, I think other than you, honey, I've met the most brilliant man in the world. And I mean, on any topic during the campaign, I could call and ask, and I don't know if you know how many times I went on your website and reading white papers, and so you truly do great work. And you all here today are supporting an incredible conservative organization. And to your board members, you're truly blessed to have Bob. Thank you. Thank you. You know, at a time when our nation's history, it's critical to remind everyone of the great first principles that founded our nation. Principles for respect for individual liberty, limited government, and personal responsibility. And when I think of JMI, it's exactly what I think of. That's what you do, that's what all of you do to help us and all the other states, all the other attorneys general continue our fight, especially here in Florida. You know, with the age of Obama, some of the biggest challenges we face are restoring a balance, as Bob talked about, between states' rights and the federal government's overreach. And I think the founders understood the federalist structure is probably the greatest source of protection for our individual liberty. And we cannot forget that. And as James Madison himself said in Federalist number 51, through federalism, a double security arises to the rights of the people. And that's what it's all about. You know, we're really facing one of the biggest battlegrounds right now, and that's what I'm here to talk to you today about. Our 26th state lawsuit against Obamacare. And I will continue to call it Obamacare because that's exactly what it is. And, you know, first I want to give General McCollum a tremendous amount of credit, because he had the foresight. He filed this lawsuit and had other states join in with him, and He invited me to watch the arguments in the Northern District. I invited him to watch them with me in the 11th Circuit. And so I do want to commend him so much for starting this lawsuit and making Florida a leader throughout the nation. You know, when this got started, there were a lot of states in the lawsuit, and then as soon as I got elected, I call it my pledge class, because we had a tremendous amount of conservative Republicans get elected as attorneys general, and some governors at the same time that I did. So we were immediately on the phone calling them saying, join our lawsuit, join our lawsuit. So now we are so proud to have 26 states, and if that doesn't speak volumes. And of course we know Ken Cuccinelli has his suit in Virginia, Scott Pruitt, my friend, has his in Oklahoma. So, you know, that, I think when the majority of the states all join hands, and I get to say it's bipartisan, because Greg Phillips in Wyoming is Democrat, and he joined our lawsuit as well. So it's so important. I mean, of course we can talk all day about the horrible issues with Obamacare. First, it's a job killer. The Heritage Foundation put out a study showing that job creation essentially came to a halt immediately after Obamacare became law. The U.S. Chamber of Commerce reports that 39% of small businesses say that Obamacare is either the biggest or the second biggest obstacle for them hiring new employees. It's also unaffordable. Former director of Congressional Budget Office has calculated that the federal spending on Obamacare will be an additional $1 trillion, additional, than they told us. Not only that, it will cost Florida over $1 billion annually. Unsustainable. Isn't it frustrating, though, to see a president who keeps trying to recycle failed stimulus plans when he's got a solution looking right at him? If he were serious about getting our economy back on track, reining in the federal debt, he would repeal this horrible health care law right now. But we know that's not going to happen. As bad as Obamacare is as a matter of policy, and for all the reasons and many more that I just listed, the bottom line, as Chief Legal Officer, the reason we are in this lawsuit is it is unconstitutional. There is no question in my mind, and from day one I have challenged any lawyer in this country to give us a case that shows otherwise. The most controversial part of Obamacare, of course, as you all know, is the individual mandate. And it represents for the first time in the entire history that Congress has attempted to force every American to purchase a product simply by being alive, by being born, by participating in no activity whatsoever. This mandate is completely unprecedented. Yet remember early on, most of the so-called experts didn't even bat an eye over it, did they? All the legal scholars out there, the liberal legal scholars, didn't even bat an eye. Let me tell you right now, thanks to Judge Vinson, we have the strongest opinion in the country, and thanks to the 11th Circuit Court of Appeals. Also, our case is truly the most comprehensive. You know, there are 28 total. You'll hear about all these other lawsuits around the country. There are a total of 28 lawsuits out there. 28. Ours, though, by far, is the most comprehensive. And I want to read you a quote from one of my favorite judges in the country, Judge Roger Benson. If Congress can penalize a passive individual for failing to engage in commerce, the enumeration of powers in the Constitution would have been in vain, and we would have a Constitution in name only. Surely, That is not what the Founding Fathers could have intended. Doesn't that say it all? You know, but there's another claim that I'm sure you're familiar with, and that's the Medicaid coercion claim. And that claim will give the Supreme Court an opportunity to decide whether it meant what it said in an earlier case from the 1980s, where it held, sometimes conditions attached to federal spending can be so coercive to the states that they're actually unconstitutional. Now, so far, you know, we haven't prevailed on the Medicaid coercion aspect. The mandate, we've always said, is the biggest, the most important legal aspect of this. But the mandate coercion, let me tell you, there's not much precedent out there. And the 11th Circuit Court of Appeal, they even acknowledged that. And in their opinion, they said they denied it with some hesitation and after serious thought. So this truly is going to be a case of almost first impression for the United States Supreme Court, given the facts that we talked about. Bottom line is, if Obamacare isn't unconstitutionally coercive, nothing is. It's because it requires the states to massively expand Medicaid rolls or risk all their Medicaid funding. How in the world is that not coercive? And under those circumstances, it's almost laughable to call Medicaid a partnership or to say that the states have any meaningful choice, isn't it? One other thing that we did that I'm very proud of after I took office, and I've practiced law for almost 20 years, but you know when you want to bring in the best of the best. And everywhere you'll hear me talk nationally, I talk about Paul Clement. Paul Clement is a true conservative, and he is really among an elite group of lawyers. He is a former Solicitor General under President Bush, and he has argued over 50 cases in the United States Supreme Court. So we brought Paul in, and he did the arguments for us in front of the 11th Circuit. You know, it's hard enough to manage one lawyer when you have 26 states all working together. And to tell you, we work tremendously well on this issue. We really do. So we flew up to DC immediately. We met with Paul. We brought Paul in our lawsuit, and he did an incredible job not only collaborating with all of us, putting all of our ideas, incorporating them into the brief, but just did really a remarkable job arguing the case. So you can be confident that our case will be argued by, in my opinion, one of the best lawyers in the entire country, Paul Clement. I also am confident that the justices will truly look at the opinion from the 11th Circuit and Judge Vinson's incredible opinion, because these opinions, whether or not you're a lawyer, you can go on our website and read them. They read like a legal treatise, but not only that, they speak in just common language that everyone can understand. And in the 11th Circuit's most basic conclusion, they said, "We have not found any general, applicable, judicially enforceable limiting principle that would permit us to uphold the mandate without obliterating the boundaries inherent in the system of enumerated congressional powers." Wow. And that was a bipartisan decision. Are you all familiar with that? From a judge appointed by President Clinton and co-authored, of course, by the chief judge appointed by President Bush. Judge Vinson was appointed by President Reagan. And I really think that the 11th Circuit is right. There is no limiting principle. If Congress can force us to purchase health insurance from the moment we're born to the moment we die, there is nothing they cannot force us to buy. Can you imagine that there's a majority of justices on the Supreme Court who would really want to obliterate our federalist system of government? I certainly hope not. If you're associated with JMI, You're probably someone who likes constitutional arguments based on the principles from the founding, just like we know Bob McClure does. And I'm probably not the only Clarence Thomas fan in this room. But you might be asking yourself, aren't the Supreme Court's existing precedents so far removed from the founding principles that we've passed the point of no return? Since the New Deal era, hasn't the Supreme Court basically given Congress free rein? Our success in the Obamacare case, once again, does not ask, and this is really important, we're not asking the Supreme Court to overturn anything because there are no cases on point. That's how out of control this health care law has gotten. What we're asking Congress to do is say, the Supreme Court to say, is enough to Congress. You know, I could talk about the healthcare lawsuit all day long, and then of course we know this is so much bigger than healthcare. You know, but we were discussing, Mark and I were discussing at lunch, there are so many other issues out there, and one is the EPA, what the EPA is doing to us. Think about that in Florida, the numeric nutrient criteria. They are trying to hold Florida to higher water standards than any state in this country. So we've sued the EPA. Just a week ago, we joined in a lawsuit with Nebraska regarding emission standards and the EPA, because that will affect every consumer in this room. You know, I can file lawsuits all day long, and we will continue to do so. We will continue to hold the federal government accountable. But I mean, I have to say, with the U.S. Senate and the presidency in play, that is why Florida is so important now, because we truly can make a difference in the U.S. Senate. And I have to talk about my friend John Rooney. He's my counterpart in Nebraska. And he is one of those Senate seats, those U.S. Senate seats. So if you don't know him, he is a great man. He's running against the Cornhusker kickback guy, by the way. And he is one of those seats that they tell us that we truly can take back. So that's very important. I'm sure you remember the infamous incident when then Speaker Nancy Pelosi asked about Congress's congressional authority to enact Obamacare. Remember that? She answered with a rhetorical question. Are you kidding? Well, Madam Speaker, we are serious. We are serious. And we have got to take back the presidency. We have got to take back the U.S. Senate. We need to be serious about electing people to office, whether they're Democrat or Republican, who believe that there are real limits to the federal government's power and are willing to respect the limits and will govern within the boundaries set by the Constitution. Because as long as there are leaders in Washington who think that there are limits, that they can place limits on our lives, on our freedom, on our liberty, we will never be secure, no matter how many lawsuits we file. Thank you for having me here today, and thank you for everything that you do to protect our rights. Thank you.